One is PET, another is Sanskrit. Both these subjects were segregated in this group of, should be segregated from one another so that it will be easier to decide the list.
Which to be segregated from which?
That item number 3. That is 31572 by 2025.
This is
that is to be segregated.
31572 of 25. That is segregated.
Yes.
31572 of 25.
Segregated, but this is also to be taken up ballot in the interim model. You will select it when you are not getting appointment.
That is
Second one is Sanskrit.
All others are, I think, Sanskrit.
First and second is Sanskrit.
Their case are different.
The others are Sanskrit.
first and second you can take.
Sanskrit.
First and second is Sanskrit.
Sanskrit.
That shall I submit to?
Yes.
Second
Before
matter,
they start, I am in the PET matter. Can it be taken up tomorrow, my lord? Or today? Tomorrow, PET matter tomorrow. It is also equal. Are selected.
Tomorrow, all right.
No, not Sanskrit. That's Sanskrit. That PET matter, the segregated matter.
Segregated matter.
That is the PET. That is a small matter can be disposed of. But tomorrow, if not today.
After seeing this, then we can take a pure matter.
No, this was.
This will start today.
Yes, no,
Let them start.
it has no nexus, I think.
That
If
is,
somebody will argue,
huh?
if somebody will try to take up these two batch of cases, then I have nothing to say. But the PET can be disposed of independently.
we can take up Sanskrit.
Sanskrit may be included, so therefore I am submitting tomorrow. So the PET is
You
concerned.
just started. Let us see. You keep it. We said even today. Also with this only we can. It will be on the same day whenever this is posted that way.
Oh, all right.
In second item,
Because the
second item,
second item is the lead case.
it is
The
the
second item is the lead case.
Second item is the lead.
16242 by 2020.
14501.
16242.
Yes. 16242.
Second item.
Avinash Mishra.
Avinash Mist.
And my lord, another
16242.
In that petition, I am the petitioner. My amendment petition, but IA number 20213 of 25 is pending.
What is that amendment?
Only to insert the apart from my other rules, only ground to for seeking direction to for preliminary exam, which has not been done as admitted.
That we have filed our objections to that.
There is more than
That we have filed our objection. The objection may be
more than 5 times in the
File objection.
5 times.
Oh, yeah.
The state has filed, so also we, the private parties who have appeared in that final exam, have also filed an objection because comes after that other order. So they are basically, it's a ground of fence sitter.
Objection which my friend has not been solved.
No, sir, please. Sir.
Not been not so.
But
What I
The
suggest,
objection filed by the commission has been solved.
Swami madam,
Yes.
what I suggest is, let us allow that application. And or we can take up that application as additional pleadings only, so that again amending and other things, it will go beyond January. That will not serve anybody's purpose.
Purpose.
So as it is, if you all agree, the application along matter itself can be taken up. The application can be taken up along with the main matter itself.
yes.
That everybody is understanding.
Yes.
That the application also will be heard along with that. But there is one risk.
That can.
Supreme Court says, where amendment is sought for, court has to pass an order on that. Permit the amendment of the pleadings so that parties will. Only thereafter court should take up the main matter is the version. But all of you agree. I can make an exception saying that the application will be treated as part of the petition itself.
Now the difficulty will be he want to change the prayer of the petition. If the prayer is now want to make, If that will be argued, then it will be difficult for us to answer.
Madam,
That may not be taken into consideration. Ignoring that amendment petition, lordship may
That
get
is the formal in nature.
One way to it. One way to it. It's been kept as an additional pleading there. We also file an affidavit replying to that additional pleading. So because
Everything.
the whole and so that our reply on merit to that amendment is also on record and everything is heard. That's just because the main approach is that if
But,
something new is coming.
Panel consensus. That will change the very structure of the petition.
Yes, exactly.
Otherwise,
Change the
that's
natural character of the case.
My lord, madam, can I interrupt your lordship, my lord? Well, I am also an applicant with a writ petition bearing number 31675 of 2020. What the amendment, what is being suggested in the lead case, the so-called lead case in the WPC 16242 of 2025, that is also there as an impugned action in my case with prayer properly structured, where your lordship on the day one issued notice to the state panel council asking him to file counter, fixing the date originally to 27th of November. Till today, my lord, there is no counter affidavit filed. So even if your lordship allows that IA, which he has filed by way of to bring certain facts by way of amendment, is allowed, that is only to make the same case, the said case, at par with my case, which is already there. So there is no meaning.
In your case, already such a prayer is there. You had no such prayer earlier. Now you have made the application and seeking permission of the court is one thing. But that prayer is already made. Yes. What Madam Pami says appears to be sensible. Since that prayer is already there in one of the
But
petitions.
the writ application has been filed recently after all these things, when this matter was argued, thereafter this was filed.
But it is
But again I have to give reply, that it will take.
then there will be no end to all this.
Yes.
No, let take up that matter. What Mr. Tata is suggesting that maybe.
When your lordship issued notice in my matter, such an understanding was also given by my lord senior counsel appearing for the department, that we will be filing the counter. That is why the short date was given. But my lord,
If I say like this, the prayer which now he wants to introduce would not much come in the way,
yes,
since such a prayer is already made in one of the petitions.
yes,
So that time can be saved.
yes. And your lord,
Our argument in fact
And it is a
major objection whether to his amendment or to Mr. Mahanti's case is this, that both of them somehow lack the locus and they have not come with clean hands before your lordships. So if that is also taken as a preliminary ground and we succeed in showing that
The petitions will go.
our objection also to this prayer is basically that.
Your objection to amendment may not fail. You might have taken that, but generally, such contentions are taken to ensure that the petitions are dismissed in limine.
Yes,
Without much discussion.
yes, your lordship.
But if that contention will remain, whether I allow that application or not.
Yes, your lordship.
So,
In fact, that might be the first thing which needs to be adjudicated to see that whether the court will at all be interested to get into the
whether the
litigation.
court will take up the matter or not.
Yes, your lordship, because it's a court of equity. Those three principles always will stay.
my lord,
That matter good to
so
do.
far as all these matters are concerned, this is squarely covered by your lordship's judgment.
Yes, in
Rendered in the case of
No.
signature, where, my lord, the advertisement condition was violated by not holding that preliminary examination, even if the valid candidatures were more than
That
5.
ratio was available.
Yes. So same thing has been asserted over here. And my lord, the counter affidavit filed by the commission in the other case reveals on affidavit that in the case of Sanskrit teacher as well as PET, the total valid applications were more than 5 times of the advertised vacancy, but still they decided to
Not to hold the.
not to hold the preliminary examination
Yes.
by a single order which your lordships have deprecated. In the single order, they are both for Hindi, Sanskrit and PET. The commission decided to hold the preliminary examination, violating the condition.
There is a difference between that case and present case.
No difference.
We have two important judgments of the Supreme Court. That your lordships, the judgment in the Hindi matter comes at the behest of a petitioner who was vigilant about his right, comes immediately to the court.
Exactly.
This petitioner here, his petitioner, sat through the hearing. Now when the judgment comes and finally everything is over, he comes to the court. Your lordships, that judgment is confined to Hindi. Even a latecomer cannot say that, you give me the same, we have a judgment to that effect. And as far as Mr. Mahanti's client is concerned, he has only come yesterday.
After knowing the fact that he has not been selected.
So selected candidate.
He comes when there was a complete notification showing that we are not going to hold the preliminary exam. He goes,
That cannot be.
participates in that examination, final examination. Document verification notice comes up. He still does not come to the court. He comes after that judgment is declared. So there are many locus points. I think that unless that is not crossed over, they cannot come up parity with that Hindi judgment. That petitioner was a vigilant petitioner.
My case is not.
He
My
had
case.
sitters. And he also makes
Not late comer. Not late comer. We had at the same time Hindi in Hindu case.
We applied that.
I'm calling this matter tomorrow.
Lordships.
From tomorrow we start.
Yes, ma'am.
Tomorrow, your lordships.
How many cases are posted tomorrow?
सोमवार
Only this matter at 2:30, 2 o'clock. Only this. Huh?
Lordship, three matters similar. Same issue. They have not conducted
Very.
three, item number 3.
Now we'll hear it tomorrow, na?
You Lordship, all the matter come. All the matters may come. Okay.
All these matters.
come tomorrow. That each matter is not done. Is item 3. I got the
Yes, yes.
I got the petition.
The last was mentioned that it shall be said, it may be second.
No matter.
No, segregated for tomorrow.
But called along.
Tomorrow, yes.
Let it come this matter. Yes. But tomorrow only.
Tomorrow it will come.
One six
In that PET matter,
16242 में
the PET matter we have filed our counter. PET matter we have filed our counter, but that has not been tagged with the file.
The count, don't call it.
Registry to put the count.
Melody in WPC. Melody in WPC.
Give copies.
Yes, yes, yes.
Counter copies. Tomorrow I will not, you can't say that copy is not sorted.
I will solve.
File the counter which your lordship directed in 31675.
How can I direct? I can only say if you want to file, otherwise not. Okay. She may argue without use of your counter.
Yes. Okay, thank you. I have article from 57. Is covered by your lordship judgment.
57.
Challenging the consent charged by the GA department from